Looking at child support, this is another very, very important area for CPAs to consider. And normally we begin the analysis at looking at the tax returns. Not a very complicated document, unless, of course, you've never prepared one. Many, many divorce and family lawyers have never prepared a tax return in their entire life, including their own, and are very, very intimidated by all the lines and information contained on a tax return. Great area to step in, help your client understand what's in the estate from looking at the tax return. Next, we want to look to figure out if there's any unreported income. 401k contributions are going to appear on the W-2, but not on the face of the 1040. IRA contributions are listed on the face of the tax return and deducted, so that income is included. Many lawyers don't understand that. And if it's a sizable 401k contribution, especially from a business owner, that can make a difference in the child support setting. Next, and usually a client's going to have a pretty good handle on this, determine if either party is voluntarily underemployed or voluntarily unemployed. And if so, the court may impute some income to that party. Again, another area for the accountant to help out. If there's inadequate proof of income, the court can do a couple of things. One, the court can stick and assign a party a certain amount of income based on the state's average per capita income, or the court can determine and reverse engineer a person's income from looking at their lifestyle. If they've got a Q45 Infiniti that's leased at $1,000 a month, but is paid for by the business, well, the court may impute that income to the individual, even though they may not see it on a W-2 or a tax return or a K-1. Also, for child support, the courts will consider, in a very big picture sense, the amount of parenting time allocated between the parties. Very important that you understand that. And the parenting expenses to be allocated. Two of the major ones are daycare and health insurance. Finally, in the big picture, total child support is going to be materially affected long-term by private school tuition, college tuition, and any other extraordinary educational expense. For our wealthy clients, it's not unusual to have one of the parties, primarily the custodial parent or the primary residential parent, say that the children need educational travel, Europe, South America, and depending on the lifestyle of the parties, that's not an unusual, and that hasn't been an unusual expense. Well, the court will seriously look at that expenditure, and that can really add some money, especially when we're talking about a trip to France that might cost $10,000. Well, that might add $1,000 a month onto a child support obligation. The key for child support is to have a good handle on what the party's lifestyle has been and what makes sense. The courts are not going to impose an obligation on someone that makes no sense at all. But it's not unusual for one party to try to push the edge of the envelope and get as much money as they can under the name of seeking it for the children. And many times rightfully so, especially if they've had a very high style of living and they don't want the children to suffer as a result of the divorce, which makes sense. But what the question comes to on the high asset, high income divorces is not what's been done in the past so much as how many ponies does each child need post-divorce. And usually the court's response is one. Children don't need 3 or 4 ponies. But if they got the money, one's enough.